Welcome back to The Explainer. Today, we're diving straight into a really fascinating foundational element of our public law system, the procedural pipeline of investigations and presentments. Since you're already totally familiar with the structure of state and jural assemblies, and you know the basic functions of grand and trial juries, we're going to go ahead and bypass all those basics. Let's just jump right into the mechanics. We're mapping out exactly how a grievance moves from, just a mere complaint all the way to a fully realized independent investigation.
So, here's our roadmap for today. 1. Introduction to presentments. 2. Receiving and reviewing complaints. 3. Evidence and fact-finding. 4. Witness testimony. 5. Grand jury review. And finally, 6. Findings and due process. Let's get right into it.
Section 1. Introduction to presentments. Understanding the core mechanism. Okay, so a presentment is actually a highly specific mechanism. Simply put, it's an independent investigation and a formal accusation initiated directly by a grand jury. Now, the absolute most important takeaway here is that a presentment stands entirely apart from your typical state-initiated charges. It doesn't require a prior court charge at all. There's no need for a prosecutor or law enforcement to kick things off. Instead, it's a tool utilized directly by the people to investigate issues, gather facts, and really hold entities accountable when, well, other branches of government might just fail to act.
And to make this whole thing possible, the Jural Assembly provides the structural framework. They offer the necessary court services and actively oversee the grand jury, trial juries, court officers, pretty much the whole shebang. This oversight is absolutely crucial because it ensures that when a grand jury initiates a presentment, it's operating within a well-regulated, historically grounded framework of public law. It's not just acting in a vacuum, right?
All right, moving on to Section 2. Receiving and reviewing complaints, the lifespan begins. Now, as you might expect, there are some pretty strict procedural steps required for an initial review. A complaint doesn't just, spontaneously become a court case. First off, the claimant has to write a clear statement of fact, and that must be formally witnessed by a state notary or an assembly recording secretary. Next, an invitation is sent to the accused to work with the assembly ombudsman for arbitration. If they agree, great. A session is held to try and find a peaceful remedy. But if they disagree, or if they just ignore it, a formal counterclaim is issued or the process advances. It's a very strict, step-by-step protocol, really designed to filter out frivolous disputes right out of the gate.
Which brings us to Section 3. Evidence and fact-finding, building the case.
So here is the crucial point. The claimant holds the burden of proof, period. It is entirely on them to present recorded facts in evidence. They have to meticulously detail exactly what occurred, specifically identify who was involved, document the exact timeline, like when did this actually happen, explain how the trespass transpired, and list any specific fees, expenses, or damages resulting from the event. It's a lot for sure, but without this rigorous standard of evidence, the investigation literally cannot proceed. Section 4. Witness testimony. Gathering perspectives.
During the actual proceedings, the structure is incredibly strict. First, the claimant presents their recorded facts. Then, any witness for the accused can provide testimony, though keep in mind this is entirely optional for them. Now, this is surprising to a lot of folks. The justice merely facilitates the room. They don't interrogate anyone. Instead, the claimant gets to ask clarifying questions of the witness, and then the jury itself steps in to ask their own questions. It's a direct, unfiltered interrogation of the facts by the very people who will actually be making the final decision.
Now for Section 5, Grand Jury Review, the independent investigators.
We really have to ask this pivotal question, because, frankly, modern assumptions often get this wrong. Does a grand jury actually need a formal court charge, or police evidence, or even executive branch approval to begin an investigation?
The answer is a resounding no. There is no way they need that permission. As demonstrated by this amazing anchor quote from the late Chief Justice Antonin Scalia, the grand jury is a constitutional fixture in its own right. It doesn't belong to the legislative, executive, or judicial branches. Because of this profound independence, a grand jury can investigate merely on the suspicion that the law is being violated, or honestly even just because it wants assurance that it's not. They don't need a prosecuting attorney to hand them a case on a silver platter. They can look around, see something shady, and just issue a subpoena for records all on their own. It's a real game changer.
Let's actually look at how this builds into real-world application by tracing the timeline of the famous 1906 Hale v. Henkel case. Okay, so after the Sherman Antitrust Act passed, a grand jury just formed of its own accord to investigate corporate corruption. They subpoenaed a chief corporate officer.
Well, the officer refused to answer questions, basically arguing there were no formal charges against him, so he didn't have to cooperate. The grand jury strongly disagreed and had him locked up for contempt. When he filed a writ of habeas corpus to the court asking to be released, the court flat out denied it. They stated plainly that the grand jury placed him there, the grand jury had the authority to do so without a formal charge, and the court could not overrule them.
This powerfully demonstrates that the grand jury operates almost as a fourth branch of government, even though technically speaking it's not government at all. It's the people. It serves as this ultimate check and balance against the courts and corporations, utilizing its immense investigatory powers to maintain accountability, especially when other branches of government might just look the other way or refuse to act.
And that leads us to Section 6, Findings and Due Process, Finalizing the Investigation.
Maintaining the integrity of these powerful, independent investigations absolutely requires some strict guardrails. And that's exactly where the Court Oversight Committee comes in. They provide the necessary oversight of the public court system and all its operations. They ensure fairness, proper procedures, and they actively investigate any claims of malfeasance, incompetence, or bias within the system itself. Oh, and they are also responsible for the strict and accurate record-keeping required so that every single step of a presentment is properly documented and totally beyond reproach.
Ultimately, due process is preserved during these proceedings through a very strict separation of powers. The justice's role is purely administrative, right? They ensure a level playing field, they make sure everyone adheres to fair rules of evidence, they keep order, and they maintain due process. Crucially, though, and this is key, the justice never rules on the facts or the evidence. That is the exclusive job of the jury. The jury deliberates, the jury decides, and the justice, they merely pronounce that decision. By keeping the power to investigate and judge squarely in the hands of the people, while also utilizing strict procedural steps to ensure fairness, the system really balances immense authority with necessary accountability. Presentments and investigations provide a structured process for gathering facts, reviewing evidence, and making informed recommendations. If the grand jury is truly designed to be an independent check on the system, the real question is, are we as citizens ready to step up and wield that authority?